If you agree to a settlement in a medical malpractice case in New York, if the defense backs out after agreeing and making a substantial settlement offer, can you now enforce that offer? Would you like to know the answer? Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is maybe yes, and then again, maybe no. When you go ahead and enter into settlement negotiations, when each side agrees upon a particular settlement, now the courts require, in fact the law requires in New York, a specific manner in which the settlement is documented. Now, the best way to do that is to agree to the settlement in open court. Now, what does that mean? It means you are in court, in front of a judge, and now everything about your settlement and all the details are put on the record, which means that there is a court stenographer in court who is recording the details of the settlement agreement. The judge is confirming the details of that settlement, and now, once everything is agreed to, now the judge recognizes it and thanks the parties for their assistance, their cooperation, and that's it. Each side can then obtain a copy of the transcript of that particular conversation, and now that is enforceable. Okay, so let's say a settlement is not done that way. You don't go into court and now nothing is put on the record. However, let's say in this instance, a phone call occurs between your attorney and the defense attorney. Is that enforceable? Most attorneys would argue, no, it technically is not enforceable if the defense backs out. What happens if the details of your settlement agreement are now put in the form of a letter or an email? Is that enforceable? The answer is, in many instances, it likely will be enforceable. However, there are issues with it. There are issues about intent. There are issues about the offer. There are issues about the conditions upon which this settlement is agreeable and conditional. And if there are specific conditions that must be met, and now the defense backs out before that settlement agreement has been concluded, now it's going to be quite difficult to go ahead and enforce that particular settlement. So just because your attorney calls you and says, hey, listen, they've offered us $5 million, you've agreed to accept it, we have accepted that offer, and now in your mind and your attorney's mind, you believe that the case is done and over and settled. And before you have a chance to send off the paperwork that will finalize your particular case and finalize this settlement, your attorney calls you back and says, listen, the defense has rethought this, they've decided to pull their offer, and now that offer is no longer on the table. Now you've got a problem. And now you say, wait a second, they have to go ahead and offer that money because I agreed to it, they agreed to it, and that's the end of it. Well, maybe yes, and then again, maybe no. So why do I share this quick information with you? I share it with you because this has happened from time to time. Not often, but it does happen, and when it happens, unless you have made sure, or your attorney has made sure, that the details of the settlement agreement are locked in and locked in tight, and there's no wiggle room for anyone backing out at that point. Unless that happens, now, if they do back out, you may have a problem. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.